feature of executive power, which is the appointment and the removal of executive branch officials. And we start from the premise that although there is one president, he can't or she can't do everything by herself. The president needs help. And the Constitution recognized that by giving the president the power to appoint and perhaps remove officers who can help him or her. Okay? So to start, where did I finish last time? I appreciate it. Is that Katie?
Sarah.
Sarah. Okay, one off. Sarah, thank you. So Sarah, to start, what's the general process by which a president can appoint an officer? For example, Secretary of State, Secretary of the Treasury, whatever office happens to be. What's the general process?
So first he nominates them.
Good.
And then with the advisory.
Great. And where do we know that from? Where?
Oh, Article 2.
Good.
Section 2.
Bravo. And it's on the board too, in case you didn't know. Article 2, Section 2. It's on page, if you know the page number, that's even more impressive. I never remember the page number. It's on page, there it is, page 30, right? And if you don't have your Constitution, which you ought to, it's right up here. President nominates officers, where it's a Secretary of the Treasury, Secretary of State, whatever happens to be. And with the advice and consent of the Senate, that means a majority vote, the officer becomes powerful. Notice the House of Representatives has no role in Senate confirmation. The only role is that of the Senate. Okay, everyone, that's reviewed. There's nothing new there. There's one other provision, though, which I haven't really mentioned before, but will actually come up today. So how many of you have actually worked for the federal government? Anyone? Yes? Where'd you work?
No, I worked in the House.
That's not the federal government. That's Article 2. That's not Article 1. That's the legislative branch, not the executive branch. Okay. Actually, this is a pet peeve of mine, right? So, no, I mean, we have separate branches. So no, I know, but it's actually different. So I actually worked for a number of years at the Department of Defense before while I was in law school. And then I started clerking for a judge. And they actually continued all my years of working for the executive branch and the judicial branch as if I had one long tenure. I thought it was a separation of powers violation, but I didn't have much to object to. Has anyone ever actually worked for the executive branch, the Department of something or other? Wow. Okay, well, I did. Okay, easy enough, right? You usually have at least one. Did the president ever nominate me to be an intern in the general counsel's office of the DOD? No. Did the Senate ever vote on my hiring? No. How did I get hired? I don't know. I applied for a job and they gave it to me, right? But wait a minute. Doesn't the Constitution say all officers are required to, go through this presidential process? What about this low-level intern like me, right? Is that Robin? Oh, which was that way? Which was? Oh, okay. Sarah. So which way? Yeah. So how was I hired, right? Did the president nominate me and confirm me? What happened? Oh, no, I worked for the DOD. It was not an independent agency, so not there yet. But under the Constitution, how would a lowly intern like me get hired without the president nominating me? And then who hired me? Yeah. So I was, in every sense of the word, an inferior officer, right? I was a lowly intern, to use the words of the Constitution. I was an inferior officer. Okay? Constitution says, Congress may by law vest the appointment of me, inferior officers, in the president or in the heads of departments. So in my case, the Secretary of Defense was my boss, like 1,800 wrong. He hired me. Probably one of the worst decisions he made. Actually, when Don Rumsfeld, it was probably one of his better decisions. But I was hired as an inferior officer. So the president does not require all officers to go through this process. The superior officers do. The inferior officers go through this little middling process below. Okay, fair enough. Now, so is Ashley? Ashley, okay. So let me ask you a question. The Constitution spells out the process by which someone can be appointed, right? Does it say anything about the process by which the president can fire or remove an officer? Does not. Is there anything in the Constitution discussing removal? Okay. This was one of the first major constitutional crises we ever had, right? The Constitution is entirely silent on the question of whether the president can remove an officer without the Senate. Okay, so now I have my two Luises, right? So Luis S. What would be the argument about why the president should be able to fire whoever he wants, whenever he wants? What's the general argument? What's the problem with the president working with an officer he doesn't like anymore? What's the problem there? And how does that affect the president's ability to execute the law? Right. So imagine this, right? Imagine you hire someone to be your secretary of the treasury, whatever else, and you're the president. You tell this person, go do X. And the guy's like, nah, I'm not going to do it. Go do what? No, I disagree. That's not a very effective officer. And he's going to actually frustrate the president's ability to do his job. So Luis B. In your mind, what is the argument in favor of the Senate having a role in the removal of officers? What's the argument there?
Well, the president only suggests who he thinks should be in charge of that position. The Senate is the one that actually approves them.
Right.
And so they should maybe have a say in whether he's doing a good job or not.
Yeah. Right. So here's the debate, right? On the one hand, you have the president saying, listen, I don't want these people working with me who don't agree with me. If I want to fire them, let me fire them, right? On the other hand, you have the Senate. You have the Senate saying, wait a minute, if we have a role in confirming them, we have a role in letting them get hired, we should have a role in letting them get fired also. Because imagine this. What happens if the president decides to get rid of his entire cabinet and hire all these awful new people? The Congress likes the old one. Should the Congress not have a say? Now, again, this was one of the first major debates in American history. And if you can fathom this, right, in the House of Representatives, right, you had people like James Madison and others arguing about this. And the Senate, you're having other people argue about this. And you have President Washington deciding whether to sign this into law. So I want to play a clip. We'll come back to this story a little bit more in depth later, but it plays it out well, of the so-called decision of 1789. There was no court case. The Supreme Court, I don't think, had even met yet at this point. But the so-called decision of 1789 was one of the first major constitutional decisions. And I hope this video works. But the question was, the audio is a little bit low, but you'll be able to hear it. Does the Senate have a role in removing officers? Now, has anyone ever seen the John Adams miniseries on HBO? Not enough hands. Okay, so there was a book by Dave McCullough called John Adams. It's a great biography, right? Read it. And they made a miniseries on it in HBO about 5 or 6 years ago, maybe longer. And I have a clip which actually shows a debate in the Senate over this decision of 1789. Now, this never happened. The Senate debates were in secret. We have no records of what happened. So this was all fictitious, but the actual vote happened. So the setup is this. You might recall that the vice president, at the time with John Adams, sits as the president of the Senate. He only gets to vote if there's a tie. Okay, here's the debate. Does this work?
The president must not be allowed to remove cabinet officers on whatever whim. The Senate must advise and consent to their removal the same as to their appointment.
Mr. McVeigh's bill is an affront to the authority of the executive branch. It seeks nothing less than to indenture the president to this body's will.
Mr. Bentley, the British parliamentary model may be instructive here. The Senate would no doubt benefit from the Vice President's learning and erudition on the subject, but I respectfully remind him that barring a tie in voting, he has no say in the matter.
No need to remind us. I concur with Mr. McClay's opinion. The President must not have unlimited authority in cabinet matters, sir.
So if he didn't get that, it might be a little bit hard to understand. The first Congress had this debate. And the debate was, we want to create a new office. We want to create this new position, right? All offices come from Congress. And they said, the president shall nominate with advice and consent whoever they want. So far, so good. And then, at the end of the bill, there was a provision that said, and oh, by the way, the president can fire this person whenever he wants. The bill said he can appoint with the advice and consent of the Senate, and then he can fire whoever he wants. Rebecca, let me ask you a question. What's the implication of Congress saying, in this case, the president can fire whenever he wants? What does that imply for the future? But what happens if Congress omitted that language? What would the implication be? No. In the very first bill in 1789, they said the president can fire whoever he wants. And then the next bill, they didn't say that. What would the implication be? Can't, right? The expressio unius thing, right? If in the first bill, Congress said the president can fire whoever he wants, and then in the next bill they said, oh no, silence. The implication was that, well, the Constitution does not allow him to fire whoever he wants. Only Congress can agree to that. And unless Congress agrees to this unilateral firing power, it doesn't exist. And then the Senate must vote on removal. That was the clip that I just showed you, right? So in the House of Representatives, led by James Madison, the very first Congress, the House said, whoa, let's not put this provision in, right? Let's not put this provision in. We don't want to create a suggestion that the president needs the Senate to remove officers. So in the House, this was pretty easily voted on. But what happened in the Senate? Go back up top, Tariq. What happened in the Senate on this very important decision of 1789? What happened in the Senate in this decision of 1789? What was the vote in the Senate? Give me the numerical vote, kind of like last night in Iowa. What happened?
I didn't know how.
No? It was a tie. Yes. We've had lots of political ties in our history, right? It was a tie. Remember that clip I showed you a minute ago where they said, Mr. President, Mr. Vice President, we only care about your opinion when it's a tie? Well, that's because it tied. The Senate split, I think it was 2020 or something like that, 1919, whatever it was. And in cases of a tie under our Constitution, the Vice President is the President of the Senate. He casts a tie-breaking vote. So John Adams, unsurprisingly, in the executive branch, voted to give the President the power of unilateral firing. He doesn't need permission. Understand? Then President Washington signed that decision. Everyone understand? So from this, Tariq, I'll go back to you. What lesson do we take from this decision in 1789? What's the lesson we take? The ink was still dry, right? It wasn't even dry. It was still fresh. What lesson do we take from that, Tariq?
That it won't be
Exactly. The lesson we take from the decision of 1789 is that the Senate has no say in removal of power. Okay? So that much is certain, right? So we have, on the one hand, we have John Adams, we have James Madison, we have George Washington, and all of them seem to agree that the president can fire whoever he wants, whenever he wants. But then we get to the year 1805 and the case of Marbury versus Madison. This is the canonical case, right? The the founder all taught to agree, which we know is wrong because Marshall screwed it up. But there's one sentence in Marbury that's relevant for our study today. Marshall wrote in his opinion, quote, that Marbury had an office that was, quote, not revocable. Marshall said that Marbury, who was a justice of the peace, his position was not revocable by the president. Catherine, what do we make of that? Didn't we just say with his decision of 1789 that the president can fire whoever he wants? How could it be that Marbury's position was not revocable? How could it be that Thomas Jefferson could not fire Marbury if he so chose to? We are 200 years before Myers. I'm asking 1805. That's why I'm doing this order. Didn't get to Myers yet. How can it be, if you're John Marshall, 15 years removed from this decision of 1789, that you just say the position can't be revoked? How can Marshall say this? How can he say this? Where's he getting this from? What do you think? We'll get to Myers later. I'm not there yet. I'm doing the history in order deliberately, because otherwise it's more confusing if I keep going back and forth. Is a justice of the peace close to the president? Oh. Catherine, other Catherine. What attribute of being a justice of the peace you think may be unique as opposed to being Secretary of the Treasury, like in terms of control by the president? The judges usually get controlled by the president?
I'm sorry, what?
The judges usually get controlled by the president. They usually take orders.
No.
Does the Secretary of State take orders? Yeah. So maybe Marshall's not wrong here, right? Maybe this justice of the peace is like an inferior officer who can't be removed at will. Maybe because he's kind of like a quasi-judge, the president can't revoke his position. Maybe because he's not taking direction from the president. But again, we have this tension, right? So we have this decision of 1789 going one way, and going the other way, we have John Marshall in Marbury versus Madison. This foundational case, right? This basic case, which we're all taught is like the greatest thing ever, and you all know is wrong. It's not. So the debate then over whether the Senate has a role in removal lays quiet for the most part until a very, very significant event in American history happened in 1863. Austin, what was happening in America in the 1860s that was so tumultuous in our history? Oh, come on. What was happening in the 1860s in the United States? It's in the reading bee. You should know this before you come to law school. Come on, Austin. What was happening in 1860s?
Oh, Civil War.
Civil War, yes, thank you. Thank you. The Civil War. You'll learn throughout the course of this that the Civil War is in many respects an inflection point in our history. What do I mean by that? A lot of the assumptions on which the Constitution of 1789 were grounded disappeared. And we've already discussed how there was a shift from a trust of the states to a stronger central government. We'll develop that theme later. But in particular, one of the major missions after the Civil War was a project called Reconstruction. Reconstruction is exactly what it sounds like. It was an effort by the northern states to basically reconstruct or rebuild the southern states. And one of the attributes of this was to effectively put the southern states under military occupation for about 20 years. There's no other way of putting it. You effectively had generals running states. The local governments were disbanded. The Confederate governments were disbanded. Military officer basically supervising all local government. As I'm sure you're aware, this created a lot of animosity and resentment. But President Lincoln was committed to this course. But President Lincoln didn't get to see Reconstruction through. He was assassinated. He was killed. The vice president, a man by the name of Andrew Johnson. Johnson was a sympathizer of the South. He did not favor brutal oppression of the South. He opposed the efforts by the radical Republicans in Congress. He opposed their efforts. So one of the first things that Andrew Johnson did upon assuming office after Lincoln was assassinated was he fired all of Lincoln's officers. He fired his Secretary of War. He fired all these people. The Republicans, who had a super duper majority in Congress, basically all the Southern Democrats, were kicked out of Congress. So there was a super duper majority of Republicans in the Congress. They said, we can't have this. We can't have this guy Johnson, this Southern sympathizer, firing all of Lincoln's men. So they enacted something called the Tenure of Office Act of 1867. The Tenure of Office Act of 1867. Zach, what was the Tenure of Office Act?
It required a senatorial consent for individuals.
Exactly right. The Tenure of Office Act required the Senate to vote before the president could fire an officer. Okay. President Johnson said this law is unconstitutional, and he ignored it. And he fired an officer. This was one of the most dramatic episodes in American history. It sounds so inconsequential, but I want you to think about it. The Congress had just passed a statute saying the president needs permission to fire someone. President Johnson said, that law is unconstitutional. I'm not going to follow it. You're fired. Shelby, what happened? What happened after Johnson fired someone in seeming violation of the Tenure of Office Act? What do you think Congress did? Come back a second. What do you think Congress did? What do you think Congress did when the president said, I don't have to follow this statute? What do you think they did? It's in the reading, but if you don't know, what do you think they did?
I don't know if this is correct, but did they, I don't think they did.
Oh, no, they did something. Do you know, Cindy? They impeached him. They impeached the President of the United States. The House of Representatives voted to impeach the President of the United States because they charged that he violated the Constitution. The law said you need the Senate to vote before you move. The President disregarded the law. The President failed to faithfully execute the law, they said. They impeached him in the House of Representatives. Shelby, let me come back to you. What happens after the House of Representatives votes to impeach? What's the next step?
The Senate has to hold a trial.
Exactly. The Senate holds a trial. Indeed, a trial at which a Chief Justice presides. It's the only mention of the Chief Justice of the United States in the entire Constitution. This was one of the most, I don't know how to put it lightly, decisive moments in American history. The House had voted to remove the President of the United States. The Senate needed 2/3 to remove. The Senate came one vote short of removal. One vote short of removal. John F. Kennedy once wrote a book called Profiles in Courage. And one of the profiles he focused on was these people in history who did something very courageous. And one of them was I can't remember the guy's name, the one person who basically decided not to vote for removal. And it was a very difficult decision. So basically they came one vote shy of throwing the President of the United States out. You know, we can always think back in hindsight, but if that would have happened, it's unclear if the Union would have sustained itself. Right? At that point, it's unclear if this fragile Union, which has just been through a bloody civil war. So we can talk about the gravity of the situation, but I want to focus on the constitutional point. The United States Congress almost threw the president out of office over a dispute on the removal of power. You get that gravity, right? This lesson I'm giving today is not some sort of inconsequential thing. The significance of the president's power to fire officers almost resulted in the dissolution of our union. I can't put that in clearer terms. This is a big deal. This is not some sort of trivial thing, right? This is a significant issue. This is about the separation of powers. So this constitutional crisis didn't quite go away. Subsequent to this, President Grant, who was formerly General Ulysses S. Grant, recommended repeal of the Tenure of Office Act, and it was repealed in 1887. Okay, 1887. So if the Tenure of Office Act was repealed in 1887, is that Natalie? No, that's a Whitney, right? If the Tenure of Office Act was repealed in 1887, why are we even here with this Myers case, right? Why is there even a question anymore about the removal of officers? Why is this even a question? What's the issue here that this is even a question?
Well, because it was which ones we could fire, right?
But if the Tenure of Office Act was repealed in 1887, why are we even here? Anyone got this one? Anyone know the answer? Real easy answer, yeah. No. Why are we here if the Tenure of Office Act was repealed in 1887? Anyone know this? Whitney, let me ask this question. Who is Myers? What position did he hold? He was a postmaster. When did Congress create the office of the postmaster in this case? 1876. Which came first, 1876 or 1887? Thank you. The Tenure of Office Act was repealed. The Postmaster Law was enacted. So even though Congress had repealed this entire provision concerning removal of officers, the Postmaster Act, I have it up here, right? The statute, postmasters of first, second, whatever, this was passed in 1876. That law still maintained that the president can only remove with the advice and consent of the Senate. So even though this was largely a dead issue, because Myers was still hired under this old statute, the Senate presumably still required to give their consent to removal. Everyone get that? I did this chronologically, deliberately, because going back and forth makes no sense, which I'm sure confused you when you're reading it. So now we're at the present, we're at Myers. So Nick, please give me the facts of Myers.
So under the 1876 rule, the president didn't get this he asked for the resignation without consulting.
I'm sorry, say that again?
He asked for the postmaster.
Who's he? Who's he? Okay, so President Woodrow Wilson, upon entering office, asked Myers to resign. What did Myers say? He said no. That's right. Okay. And then what happened next? After Myers refused, what did Wilson do? What's this entire case about? What did the president do after Myers refused to resign? What's this case about, Nick? So what did Wilson do after he refused to resign? He fired him, right? He fired him. President Wilson told the Postmaster General, that's the big honcho, right? Big cheese, fire Myers. And he was fired. He was removed from office. And he hired someone else to fill his place. William, why are we in court? What is Myers' beef here? What's his injury? Why are we even in court? Yeah, but he was fired. So what? We usually don't go to federal court when we're fired. What's the beef here? What's the injury? Well, that's a political question, right? But what's actually the injury that he suffered? Think about it. Imagine you're fired from your job. So you had a 5-year contract and you're fired from your job. What are you going to be annoyed about? Money! He was suing for the amount of money he was due. He had a 5-year contract, whatever it is, right? He still had some time left in his contract. He was suing for the monthly payments that he was due. That's why we're in federal courts, my friends, right? You cannot go to federal court and simply allege a violation of separation of powers. You can't say, you know what, president broke the law, I'm going to sue him, right? This is why someone asked me at the Ted Cruz situation. You can't just go to court and say, hey, is he a citizen, natural born? You need an injury. Here, the injury suffered by Myers is that he wasn't being paid. That is an injury which you can go to federal court. And it requires the court to resolve the constitutional question. And the constitutional question is this. Is this statute constitutional? Can Congress require the consent of the Senate before someone's fired? Or does this infringe on the executive's powers to manage his own workforce? We've already said the Constitution makes clear you need the advice and consent to appoint. It's silent on removal. Can Congress add an additional limitation on the executive power? The Constitution, of course, can limit executive power, but statutes may not be able to. Okay, everyone get the question. Is this statute, right, this postmaster stupid statute, which no one cares about, this is one of the big separation of powers cases of all time. Sean, was this statute constitutional? Did Congress have the power to condition removal on a Senate vote?
I believe at first they say it was. And then,
I'm just talking about Myers. I'm not talking about Humphrey yet. I'm asking about Myers. What did Myers say? What was the holding of Myers?
that it was not.
That what was not constitutional?
The postmaster statute.
Why was a postmaster statute not constitutional?
Because it infringed on the president's executive
Exactly right. Okay. So based on the history we discussed, the court looked to the decision of 1789 and said, listen, the mere fact that the very first Congress made this decision, that doesn't resolve the issue in its entirety. But look, they were really close to the Constitution. Many of the same men who drafted the Constitution were in the first Congress. We'll go with them, right? We'll go with them. And the court holds that Congress may not place limitations on the removal of officers. What about Marbury? John, what about Marbury? We had John Marshall, this giant who was a statute from the Supreme Court, right? What in the basement of the Supreme Court? How do we just write off Marbury? What do they say?
That it wasn't close enough related to the executive power. Like, is it the postmaster, I guess?
Well, you're actually giving the better answer. That's what I said before. That's actually the better answer. What did the court say? What did the majority opinion was written by Chief Justice William Howard Taft. And Chief Justice Taft is unique in that he's the only person to be both president. The guy was huge. There's a story which is probably fake, but I think he would have 400 pounds. There's a story that he apparently once rode a horse and broke the horse's ankles. And then, this part's almost certainly fake, but it's repeated that a group of animal rights activists said we should get the president an elephant. That way he won't break their ankles. In fact, he was originally a judge on the Court of Appeals in Cincinnati, where I clerked in the Sixth Circuit. And there's actually his chair. The chair used to sit in, and it was like this big. It was like this huge chair. But Chief Justice Taft is unique because he was both president and then later Chief Justice. Zach Cash, what do you think President Taft's perspective is on executive power in light of his past experiences? How do you think he views Congress trying to limit the president's powers? Why would he not like it? Come on, he was a former president. Why would he not want Congress chipping away at the executive's powers?
Probably thinks that probably appreciates the separation of powers.
Yeah, good. So there's actually a history here which you may know of. So President Taft came into office after President Teddy Roosevelt. President Teddy Roosevelt, among his many attributes, was he was a naturalist. He loved nature. He loved the forest. That was one of his big virtues. Taft, not so much. So there was actually, I think he was the Secretary of the Forest or some such office, was doing stuff that Taft didn't like. And then Taft fired the guy. And this made Roosevelt livid. In fact, this is part of the reason why Roosevelt ran for president against Taft as a bull moose during the next election. But one Taft's most controversial decision was to fire this guy who was a holdover from the Roosevelt administration, right? So Taft understood very well what it means when you come into office and you want to put your own people in office. You don't want to have, the previous president's officials. So Taft got this. What about Marbury, though? Let's go back to the question. Is that Delaware? What do we do about Marbury? How does Chief Justice Taft reconcile, Marshall? What does he say? He does it very quickly, without much thought. What does he say about Marbury? He says basically one sentence sums it up. What does he say about Marbury? Anyone? What does Taft say about Marbury?
Dictum.
It was dictum. What's dictum?
Just basically you're expressing an opinion that's not really a binding opinion.
Yes. So there's this concept in legal jurisprudence called holding and dictum, right? I'm sure you've been exposed to it. It's a very nebulous line. But roughly speaking, a dictum is a statement that is not necessary to the holding. What was the holding of Marbury? That Congress can't expand the Supreme Court's original jurisdiction. That was the black letter holding. Was it necessary for John Marshall to discuss whether an official could be fired, whether a position was revocable? Was it necessary to get there?
No.
So Taft says, ignore that sentence from Marbury. Just write it off. It's a dictum. Imagine that, right? I mean, we know that Marbury's wrong. And apparently this part's dictum. This is why I'm not a Marshall fan. The opinion was littered with errors of the worst sort. By the way, Marshall was copying Hamilton. Hamilton said the same thing in the Federalists, by the way. Go back to that later. Most things that Marshall were actually from Hamilton first. He was a copycat in many respects. But Taft says that's dictum. And in very broad language, he says the president's power of removal is absolute. No limitations can be placed on it. We looked at the decision of 1789. Marbury's dicta. And what about that Tenure of Office Act stuff to Reconstruction? Oh, that stuff's too complicated, right? That was very, that was very testy times. We will lay down the rule. Simple. President can fire whomever he wants, whenever he wants. No limitations by Congress. That seems pretty clear, right? It seems pretty clear. Delarm, go back to you. What did Justice Brandeis say in his dissent? And be sure always read the dissents. Very often the dissents are more important than majority opinions. What did Justice Brandeis say in his dissent? Yeah. So what Brandeis says is, look, this decision of 1789 was about these superior officers, these high-ranking officials. This guy's a postmaster, right? I mean, yes, that's before email, mailing was actually very important, but this was an inferior officer. And for inferior officers, the president should be able to fire whomever he wants. Okay? This position is too broad for these low-level officers. She'll be able to fire whoever she wants. And by the way, this is Justice Louis Brandeis, who's on the court. All right. So does everyone get the holding of Myers, right? If you were to read Myers in 1920, whatever year it was, if you were in law school during that time, the holding was so clear. The president can fire whatever officers he wants, period. That seemed like a fair statement of the law after Myers? Yeah? Okay. Any questions on Myers? We go to Humphrey. So what happened between Myers and Humphrey is a question that has been driving law students nuts for about 70 years. And let me explain why. Traditionally, when I asked before who works for the federal government, I was asking for executive branch agencies. I'm talking about the Department of State, the Department of Treasury, Department of Labor, you name it. These are all agencies which are at the direction of the president. The president can appoint the Secretary of the Treasury, the president can appoint the Secretary of State, whoever he wants. But at the turn of the 20th century, in the late 1800s and the early 1900s, Congress came up with a new idea. Rather than having these agencies dependent on the president's will, Congress created what were called independent agencies. Independent agencies. What are these independent agencies? They were these boards which had some sort of function that was similar to an executive branch agency, but they also did other stuff. So to give you an example of one of the first ones, it was called the Interstate Commerce Commission. The Interstate Commerce Commission. The ICC didn't just enforce laws. They also had powers to enact these new things called regulations. Now I realize most of you have no idea what a regulation actually is. Laws that are passed by Congress are called statutes. Rules enacted by these administrative agencies are called regulations. Wait a minute, Josh, wait a minute, that can't be right. Didn't we say that all legislative powers are vested in Congress? How can these Humpty Dumpty agencies make rules which bind us? Okay. Congress has delegated to these agencies the power to make regulations which look an awful lot like laws. If you look at a statute and look at a regulation, you won't even know the difference. But I, as my students at least, never ever forget the difference between a statute and a regulation. The statute's voted on by Congress. Regulation is written by some bureaucrat in Washington somewhere without any sort of a political accountability through election. Okay? So these administrative agencies have this sort of quasi-legislative power where they can make these regulations which have the force of law. But they don't just enforce these regulations, they adjudicate them. Huh? If you're found to violate these regulations, you don't go straight to a federal court with an Article III judge. No. These agencies have their own, I'll put this in scare quotes, judges. Judges, call them Article I judges. They're not really judges, they pretend to be. They wear robes, but they're not really judges. Okay? And these judges exercise the power to interpret the regulations that the same agency administers. So look at this. What is this independent agency? They're not accountable to the president. They have executive power. They can enforce the regulations. They have legislative power. They can write regulations. And they have judicial power. They can adjudicate their own regulations. So what the hell is this constitutional chimera, right? What is this? Neither fish nor fowl. This is a product of the 20th century. And we will discuss in later classes how the court upheld the constitutionality of this blending of the separation of powers. But today there's one attribute that I want to focus on. Who is at the head of these executive branch agencies? And the short answer is a bipartisan commission. A bipartisan commission. So generally speaking, these boards are created with 5 members. 5 members. 3 appointed by the president in power. So right now it'll be President Obama appoints 3 Democrats. And then 2 of the minority party, there'll be 2 Republicans. So at any given point, these 5-member boards, it's almost always 5, have a 3-2 breakdown. Some issues are, unanimous, and other more, political issues are voted on partisan basis. The reason why Congress created these independent agencies like this was to insulate or protect administrative law from the whims of politics, that the president couldn't just fire whomever he wanted whenever he wanted, right? These agencies, for example, the Securities and Exchange Commission, right, or the Federal Election Commission, or the Federal Trade Commission, right? Whenever there's a commission at the end of the agency's name, these were created to be independent from the political process. Okay, everyone get that much. The book doesn't bother explaining any of this, but it's actually very, very essential. So one of the commissions in the 1930s was called the Federal Trade Commission. And as its name would suggest, this board was responsible for creating. Now, I've already said that one of the major inflection points in American history was the Civil War, as far as the Constitution is concerned. Another major inflection point was the election of Franklin Roosevelt. And this is a period we'll be discussing significantly throughout the course of the semester. Roosevelt's election affected a revolution in constitutional law and a concentration of power in the executive and the federal government that was heretofore unimaginable. So when Roosevelt was elected, one of his first actions, what am I saying? What are the facts? Okay, so talking too much. What's up to? Thank you. Okay, that's Sydney, right? So Sydney, what happened after President Roosevelt came into office? And that's Mr. Humphrey. Mr. Humphrey was still in office. What happened? What did FDR do to Humphrey? Good. Okay, good. I'll come back in a second. So what happened? Humphrey had been appointed to a term of 6 years by President Calvin Coolidge, the president some years earlier. Oh, he had a 6-year term in 1931, and I think that was President Hoover at that point. Roosevelt came in and said, you know what? You're just not working for me. You're a Republican. I'm a Democrat. I don't think you'll support my ideas. I want to put my own guy in this board. You should resign. Okay, Sydney, what did Humphrey tell FDR? He said no, just like Myers. He's like, screw off. I have my fixed position, right? I got my 6-year term. I have my guaranteed salary for that position. You can't fire me. What did Roosevelt do, Sydney? He was removed. Okay, so is that Felipe? Yeah. So Felipe, imagine you're President Roosevelt's Attorney General, right? And he comes to you and says, hey, Felipe, I really want to fire this FTC commissioner, this Humphrey guy. I don't agree with him. Do I, as president, have the authority to fire you? You're his lawyer, right? You're his Attorney General. What do you say? Based on the law as it existed in 1935.
Yeah.
What precedent, what cases do you cite for your Attorney General? What do you look to? What case did we just discuss?
Yeah,
Myers. And if you look to Myers, what does Myers say? What's the holding of Myers? Exactly. General Felipe, you say, look, President Roosevelt, you got this, right? Myers, the United States says you can fire whomever you want, whenever you want. This goes all the way back to James Madison, 1789 decision. Mr. President, you're good. Everyone think that'd be good legal advice? Would you not be sued for malpractice, right? I think you'd be on fairly safe grounds giving This advice to President Roosevelt. Anyone disagree with me? Stand up. Anyone disagree with me? Okay. So Roosevelt goes ahead and fires Humphrey. And just like the last case, Humphrey sues. Why? He wants his paycheck. He wants a salary. In fact, Humphrey dies. And I'm going to say this lightly, I can't find his obituary. I've looked for it, right? The circumstances of his death are very curious. Right? People have looked into it. We have no idea how this guy died, right? He was a fairly prominent figure. There's no record of his death. I'm not saying anything, but I've looked into it. I have no idea how he died. But even though he died, Humphrey's executor, the executor of the estate, kept suing for the money because if you die, your estate can collect whatever debts you're owed. That's a matter of property law. So they brought suit to recover his salary. And this case goes to the Supreme Court. So the question becomes, Angela, are we governed in this case by Myers? Does Myers provide the rule of decision for Humphrey's executor? I'm sorry? That's not the right answer. We just read Myers. Does Myers provide the rule of decision for this case? Why does Myers not provide the rule of decision? You're right. Humphrey held that you cannot fire Humphrey. Why is this different from Myers for the United States?
Because you need the consent from the Congress from Senate.
Wait, no, hold on. Angela, we just said a minute ago the president's power removal is absolute. 5 minutes ago. We all agreed. No one argued with me. Why is this case different? Bingo. So here's the rule, right? Here's why Myers and Humphrey's executors come out differently. The court says a different rule applies for the independent agencies. That Congress has the power to create these independent agencies and insulate or protect their officials from removal. Congress can say you can only fire the guy if he's incompetent or he's not doing a good job, and there was no argument that Humphrey was incompetent. Roosevelt just didn't like what he was doing. So what comes next is a very difficult balancing act, right? Daniel, how does the opinion in Humphrey read the decision in Myers? What does it say about it?
It says that like a postmaster is an executive officer, so somebody in the executive branch can say you are removed, but he has no ability to do something with a judicial or legislative body.
Okay, that's exactly right. So first, the court in Humphrey basically reads Myers very narrowly. What do I mean by that? They said the narrow point that was decided in Myers was only that the president has the power to remove a postmaster without Senate. Myers held that long opinion you read and suffered through, right? All that stood for was a proposition that a postmaster can be fired by the president without the Senate. That's all it held. Did anyone think that, Daniel, when you read Myers, did you think that was the holding of the case? No.
Not that narrowly.
No. So basically, the court in Humphrey reads Myers so narrowly. You had this broad language by Chief Justice Taft, right, about the power of the executive and how important it is to choose your officers. And then you have this, and oh, no, that was just about a postmaster. No big deal, right? It's really hard to take this part of the decision seriously, right? I mean, the same way that Myers called Marbury versus Madison dicta, Humphrey just called Myers dicta, right? Don't like a decision, they say, oh no, that was dicta. That wasn't really part of the case. It's really narrow. I don't want to call it disingenuous, but it gives you a very icky feeling when you read it. They read it away. But Daniel is exactly right. The court says that the position in Myers, this postmaster position, was purely executive. purely executive. Delivering mail is purely executive. In contrast, the FTC, right? The FTC is this quasi-legislative and quasi-judicial branch of government. Cody, what does this mean? Quasi-legislative, quasi-judicial. What the heck does this mean?
It means that some of their duties are making laws and some of them are deciding laws.
Exactly, right? I discussed this a few moments ago, but these various agencies, like the FTC, for example, they're not just no. They also make regulations themselves on trade policy. And oh, by the way, if you violate those, they'll haul you in front of one of their own fake judges who wears a robe but's not really an Article 3 judge. This, the court says, is not consistent with an absolute removal power. Because they have powers over the courts, and because they have the powers over this quasi-legislative act, the president cannot have absolute authority. And indeed, it's here they cite Marbury and say, wait a minute. The reason why Marbury cannot be fired was because of the justice of the peace. He's judicial. You see how they did that, right? That stuff which Taft ignored, they brought it back here. Because Marbury was the justice of the peace, he's judicial, you can't revoke that at will. So the bigger question, the question you should be asking yourselves is, how is this constitutional, right? How can Congress give away this executive power, give away this legislative power, and give away this judicial power? The short answer is the Supreme Court says we don't care. We'll discuss this later. But this is a species of what's called the non-delegation doctrine. I mentioned this last week. The non-delegation doctrine. This is the notion that Congress can't give away its constitutional powers, right? That it must retain this power. With these administrative agencies, the Supreme Court basically said, forget about it. We're not going to care for this non-delegation doctrine. And after 1936, the Supreme Court basically gave up on the non-delegation doctrine. We'll come back to this later, but just flag it in your notes. The reason why these agencies can even exist is a threshold question, right? Is whether Congress can give away this sorts of power. Yes, hold on, that's John.
So I understand the legislative issue, but how can you judicial power being transmitted? I feel like
It's a serious issue. So we'll do a case called Schechter Poultry in about a month or so. We'll come back to that. So one of the big issues is you're effectively giving these Article 1, they're not really judges, but they're people who wear robes, right? Giving them the power to adjudicate your life, liberty, or property.
Are they arbitrating?
Whatever they want. They call themselves that. They're called administrative law judges now. That's their title. But generally speaking, they have very broad powers to assess things. And even today, we have lots of administrative courts. So, for example, if you have any veterans, right, and you have a dispute, you go to the Court of Veterans Affairs. If you have a Social Security dispute, you go to the Court of Social Security Affairs, right? There are these specialized administrative courts that decide your property and liberty rights. And again, the court blessed these, even though they're not Article 3 judges. The caveat, which I'll stress, is if you disagree with these administrative courts, you can appeal to an Article 3 judge. You can appeal to a real judge at some point, but you have to first go through this administrative process to exhaust all your remedies. So the holding then of Humphrey is the president's removal power depends on the character of the office. Okay? The president's power to remove depends on the character of the office. Myers, this absolute removal power, Myers only extends to purely executive officers. So for purely executive officers, the power of removal is absolute. But for these so-called independent agencies, Congress can put strings on removal. Everyone get that? Tariq? Yeah.
So the Constitution can be silent president's power to do.
Right.
Find each statute has its own regulation. How can you resolve this conflict between silence of the Constitution and all those organizations having their own statutes?
So the short answer is, if any conflict between the statute and the Constitution would prevail, who gets to interpret the Constitution? That's your answer. The Supreme Court read the silent Constitution to mean there are no possible limits on removal power. So even though you have a statute on the one hand, like Greek said, and you have the Constitution with the sign on the other hand, the Supreme Court puts its own interpretation of the Constitution, and that trumps the statute. This is the issue of Marbury, right? This is the issue of who gets to decide. Does the Supreme Court have the final say? Here, the Constitution, I mean, frankly, is silent. Doesn't say one way or the other. But they interpret it in that manner, and the Supreme Court's interpretation of the Constitution trumps the actual statute of Congress. Even though Congress thought this was constitutional, the court said, no, no, you guys are wrong. We know better. Hence the Supreme Court's assertion of they know best. Questions then on Myers or Humphrey? Yes, sir.
So if he did violate section 1 of this FTC Act, then the president can unilaterally remove.
Yeah, so if he actually engaged in negligence, or he didn't do his job, or he didn't show up or something, he can be removed for cause, right? You can always fire someone for cause. But here Roosevelt said, I am going to fire him because I don't agree with the guy. And there's a very different standard between firing someone for cause and firing them because you don't agree with their policies. So there's a different standard.
What is cause?
Yes.
Does every agency have something?
Every administrative agency has a provision to fire someone for cause. There's always, if someone doesn't do their job or doesn't come to work or whatever, you can fire them. But it's very specific. Okay. Any other questions on Myers or on Humphrey's executor? Anything? Yes, ma'am.
So right now, the president has the power to fire people from the executive. Is it still?
So there's a case that I didn't assign, but it's in the reading, and the reason why I didn't sign it was it gets complicated. But the short answer is purely executive officials can be fired at will. Independent agencies maybe can't, and certain inferior officers can't. It gets complicated. So for your purposes, know that the purely executive cannot be fired. I'm sorry. Purely executives can be fired at will. Independent agencies can't. That's good enough for now. There's another case where, again, I didn't assign because it gets even more complicated, and it doesn't really resolve much. There's been lots of big separation of powers cases involving removal. It's been very significant. The case I didn't mention involves something called the independent prosecutor. So following Richard Nixon or threatened impeachment, following Nixon's resignation, Congress passed something called the Ethics in Government Act. And the Ethics in Government Act said we're going to appoint a special prosecutor who is not answerable to the Attorney General. In other words, there's going to be a prosecutor who can't be fired by the president. And this prosecutor can investigate whatever he or she wants. And this was used a number of times during the Reagan and then Clinton administrations to investigate various political things. So most famous one is Ken Starr, and prosecutor to investigate the Clintons. And what started off as an investigation of the Clintons' travel room scandals, which was fairly small, expanded to Lewinsky, and then that Bill Clinton lied under oath during a deposition, which ultimately led to President Clinton's impeachment in the House of Representatives. Thankfully, Congress let the independent counsel statute expire because it was really, it wasn't a good idea. It was a bet. It seemed like a good idea after Nixon, but it did not work out well. So, but there was an entire case of whether the president could fire the independent counsel. And the court basically said, no, you cannot fire this independent counsel, even though it's entirely independent, but it does have an executive function, right? Prosecution is an executive function, but it's independent. So like this weird hybrid thing where it's kind of like Myers, it's kind of like Humphrey, I don't know what it is, and the court by a vote of 8-1 said you cannot remove them. The case is called Morrison v. Olson. Morrison v. Olson. Okay. Any questions on Humphrey or Myers before we move on to Noel Canning? All right. So The second case I asked you to read, Noel Canning versus National Labor Relations Board. It's probably one of the most important cases of the Roberts Court, one of the most important cases of this new century. And the reason why is that separation of powers cases are fairly rare. There's a reason why the three cases you have today are like, 1920 something, 1930 something, 2014. They're really spaced apart. It's very rare that these sorts of constitutional questions go to the court because courts don't resolve purely political disputes. They don't. What makes these cases unique is that there are private parties who are injured. They didn't get their salary, right? When there's a private party that's injured, that's how you get yourself into federal court. So I'm going to actually show you, I lecture on this case quite a bit, so I'll show you a presentation I give. I don't do this often, but it's a case I lecture on quite often. So the National Labor Relations Board is an independent agency, okay? It was founded during the New Deal. They always have these eagle scary logos. They always do. By the way, it's actually a myth. You may have actually heard this, that in the president's logo, in one talon is a claw full of arrows, and the other talon is a claw full of olive branches. And the eagle's head is facing the olive branches and not the talons, as a symbol of peace. You may have heard that in times of war, the eagle's head changes, it faces the arrows. It's not true. There are a couple of icons in the White House where it's facing the arrows. I think that was mostly inadvertent. So you always have these ominous eagle statues, right? So the National Labor Relations Board has 5 members, 5 seats. 3 appointed by the president, 2 appointed by the minority party, okay? So you have 5 chairs. If at any point the board falls below 3 members, right? If there are only 2 people on the board, they lose what's called a quorum. And once the board loses its quorum, it can't transact business, right? Unless they have 3 members, they can't transact business. So during the Bush administration, when President Bush had appointed 3 conservatives to the board, what happened? Democrats had this genius idea. They said, I got an idea. The way we shut down this conservative labor board from making conservative policies is we will not confirm anyone to the board. There were these protests saying, shut it down for innovations, right? So they basically blocked all of Bush's appointments to the National Labor Relations Board. They blocked them because the Senate Democrats were in the minority. They could filibuster and block the appointments. So at one point, 2 is the loneliest number. The board fell to 2 members. They lacked a quorum. They tried to transact business, but the Supreme Court said, no, you can't do this. You need at least 3. Okay? So what happened? They said, I love this picture. It's at the end of a long hallway, right? So what happens afterwards, after all this gridlock? Well, in 2008 or 2009, after President Obama was elected, the Republicans took the exact same tactic, right? So the Democrats blocked Bush's appointments to the board, and now Republicans blocked Obama's appointments to the board. It was the exact same strategy in reverse. Justice Scalia mentioned this in his concurring opinion. And Obama nominated this guy, Craig Becker, to the NLRB. He was a former union lawyer, and this occasioned a massive political fight. And there was a serious campaign saying, vote against Becker, block this guy to the board, he's a radical, whatever. And they blocked him. The Republicans had enough votes in the Senate to block his nomination. So what happened? The board was about to drop below 3 members once again. And again, once the board drops to 2 members, they can't transact business. So what happened? Recess, right? So we have the recess appointment clause. I want to walk you through the text of the clause. Okay. So we've discussed the general method by which the president can appoint people. And the general method, the president nominates someone, and then with the advice and consent of the Senate, the person becomes the officer. But the Constitution provides an alternate method for the president to fill vacancies. The Constitution says in Article 2, vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of the next session. We're going to come back to the meaning of this clause later, but I wanted to just mention up front that the Constitution does provide this alternate method of appointing people. Oh, I love this quote from Mark Twain. No man's life, liberty, or property are safe while the legislature is in session, which is indeed true. And apparently, even when they're not in session, they can still do stuff. So, so what happened? Okay, we have what's called a pro forma session. So let me explain what happens here. From December of 2011 through January of 2012, the Republicans' plan was this. We are 3 days. Why? Because once the Senate goes into recess, President Obama can fill this National Labor Relations Board. So the Republicans said, we're going to prevent President Obama from filling these positions. How? By every 3 days holding a pro forma session. What is a pro forma session? If this video works, I will show you. Hope this works. This is a pro forma session. So I never trust videos to work in class. I'll explain it. So the purpose of these pro forma sessions is one member of Congress, usually a senator from Virginia or Maryland, because they're always nearby, comes into the body and he gavels into order. I'll show you this video that actually works. There it is. Okay. So if you notice, the entire Senate is empty. Okay? And you see one senator going to the chair. It's really short. If you blink, you'll miss it. See, no one's there. Only people who are there are the stenographer, you have the clerk. Get very close to 901.
The Senate will come to order. Pursuant to the Constitution, the hour of 12 noon, January 3rd, having arrived, the Senate convenes the second session of the 112th Congress. The clerk will read a communication to the Senate.
Washington, D.C., January 3rd, 2012. To the Senate. On the provisions of Rule 1, Paragraph 3 of the Standing Rules of the Senate, I hereby appoint the Honorable Mark R. Warner, a senator from the Commonwealth of Virginia, to perform the duties of the chair. Signed, Daniel K. Inouye, President Pro Tempore.
Under the previous order, the Senate now stands adjourned until 11 a.m.
That's it. That's it. And I play that video deliberately so you get the entire flavor. It lasts less than a minute long. So what happens? A senator, again, from Virginia, usually or Maryland, comes in. He gavels. They read a message saying, hi, everyone. We're here for this new session. We gavel out. Done. So the question is, can the president make a recess appointment during the 72-hour gap between these pro forma sessions? But the deeper question is, are these stupid little pro forma sessions, do they even count? Because think about it, right? If you hold these stupid pro forma sessions every 3 days, if those don't count, Congress was on a recess for 3 weeks. So the question in this case is, can President Obama make a recess appointment during this three-day break? So for decades, the president's advisors in the Office of Legal Counsel said, no, 3 days is too short. You can't do this. But the president's lawyer said, no. This is not a break of 3 days. Stupid promotions don't even count. This was like a 2-week break. You're good. Go for it. Appoint them. And on that advice, President Obama made 3 nominations to the Labor Board. They had their quorum. See how happy they are, right? They were there. They were complete. And they made a decision. They made a decision in their adjudicative function as like almost a quasi-court. See, they're not even wearing robes. Pathetic, right? but they made their adjudicative decision against Noel Canning. Now, the case is not called Canning. It's actually the name of a company, Noel Canning. They are a bottling company. They bottle Pepsi Cola in Yakima, Washington. Let's say that word, in Yakima, Washington. And the National Labor Relations Board issued a decision against them. It was a collective bargaining dispute. It doesn't really matter what it is. But they said, wait a minute. Hey, NLRB, you just issued the decision against us? Guess what? 3 of your members aren't really there. Because 3 of your members were not adequately appointed, the decision against us is void. And because the decision against us is void, you can't rule against us. You have no quorum. So they actually challenge in federal court the decision of the president, the decision of the board to rule against them. And the Court of Appeals ruled in their favor. They said, listen, you guys, you are not validly appointed. Rule for Noel Canning. So this case goes to the Supreme Court in a serious separation of powers dispute. Again, these don't come up very often. They're fairly rare. In fact, we seem to have one every year now, which is really rare. We had National Labor, the NLRB last year. 2 years ago, we had Noel Canning. Last year, we had Zivotofsky, which you have to read for next class. And this year, we have the United States versus Texas immigration case. We seem to be having a serious separation of powers case every year. This is actually fairly rare, but such are the times. So this case goes to the Supreme Court, and we'll go through the opinion more later, but I want to focus on one aspect of the oral arguments that are very instructive. So we have Justice Breyer, and we've discussed Justice Breyer at length, and he is a pragmatist. He tries to say, how do we make democracy work? How do we make things work better, right? Another thing about Justice Breyer is that he worked for many years in the Senate. He was the legal counsel to Ted Kennedy, who was a longtime senator from Massachusetts. And Justice Breyer is all about making government more efficient and deferring to Congress. And when he wakes up in the morning and says, man, how can I give Congress more deference? And that's what gets him going in the morning. Justice Scalia is a formalist. He is a textualist, meaning he follows the text of the Constitution. He considers himself an originalist, that he follows the original meaning of the Constitution. He doesn't particularly care what's effective. He wants to say, what does the Constitution say, and let the other branches deal with it. So one of the themes that came up in arguments had to do with what's called intransigence. Intransigence means, a partisan fighting, right? Where one party won't support the other. And I mentioned this at the outset deliberately. During the Bush administration, Democrats blocked Bush's nomination to the Labor Board. And during the Obama administration, Republicans blocked Obama's nomination to the board, right? This has become a political football, right? The way to shut down a labor board you disagree with is to block them from having a quorum. This has been going on for now at least 10 years. So during the arguments, right, this theme of intransigence came up. And Justice Kagan, who's the newest justice, I'm a big fan of hers, said, these recess appointments, right, these were designed for the era of the horse and buggy, right? When someone died in the middle of a summer break and everyone was back at their farms, the president needed to make a temporary appointment to deal with this emergency, right? But we're not there anymore, right? We have phones, and you can basically be across the country in 24 hours. So Kagan, if I can meme the Supreme Court, Kagan said, these recess appointments, they're not dealing with congressional absence. Right? President Obama didn't use the recess power because he couldn't get the Congress in session. In fact, they were fighting over these nominations for months. He used them for congressional intransigence. So congressional absence with congressional intransigence. And I think this was a very astute point. She said, look, you're not using this as a way it was designed for. It was designed for when Congress was out of town and there were no cars, everyone was on a horse. You're using this because Congress want to approve your guys and girls. So then the Solicitor General, a guy named Don Verrilli, we'll come back to him several points this semester. The Solicitor General is the top lawyer for the U.S. government. And Don seems to have to argue a serious separation of power fate. And Verrilli goes, well, wait a minute. The recess power acts as a safety valve for that intransigence. And I want to dwell on that point for a second because it's actually quoted in Scalia's concurring opinion. What does it mean for the recess power to be a safety valve given that intransigence? So if you think about what is a safety valve, right? On a tea kettle, when you know I'm a little teapot, right? When the teapot gets all steamed up, you hear it shout, and you tip it over, and you pour it out, right? The steam comes out. So what the Solicitor General basically said is when Congress gets so gridlocked and Congress gets so animosity, right? The president can use this executive action, this executive power, as a way to relieve some of the gridlock in Congress. And the recess power gives him that authority to do so. Right? This was the Solicitor General's argument, which he made. So the justices did not seem particularly pleased by that across the board. Again, the government lost this case 9-0. This is also one of the rare separation of powers cases that isn't really 5-4, although it really was. We'll get to that later. And Justice Alito goes, this is a very aggressive argument in favor of executive power, that the president can just let some steam out. And then Chief Justice Roberts says, wait a minute. The Senate has an absolute right not to confirm anyone. The Senate has no duty to confirm the president's nominee. If the president nominates Craig Becker and the Senate says no, nominate someone else less controversial. Now, John Roberts is speaking from some experience here. Why? When he was coming up to be Chief Justice, do you know who voted against him? Senator Obama. And when Justice Alito was coming for nomination, do you know who voted against him? Senator Obama. So, and Senator Obama tried to filibuster Sam Alito. So we have history here with basically the president, who was formerly a senator, blocking the nominations of the very people asked to uphold his appointment. So there's some history here, right? There's background, as they say, right? But then, we have this theme of gridlock, right? And on this point, Breyer and Scalia, I think, mostly agree. During the arguments, Justice Breyer explains, look, when Congress won't agree on who to vote for, this is a political problem. This is not a constitutional problem. The mere fact that there's political gridlock does not license the executive to heighten his executive powers. The mere fact that there's disagreement does not give the president more powers. In fact, it's to the contrary, as Justice Scalia said, right? I got the quote right here. Scalia writes this in his opinion. Gridlock is not some sort of bug in the Constitution. It's not some sort of error that has to be fixed. This is a calculated feature of our constitutional framework. Scalia writes, this is a calculated feature. In other words, I think I said this before, when the branches are butting heads and not accomplishing anything, that's in many respects a sign things are working, right? We don't make it easy to pass laws. We don't have a parliamentarian system where the prime minister and then the legislature are the same party. There's disagreement, right? Now, does this mean that Congress can't pass any laws? Of course not. But when Congress is at such loggerheads, this is a reflection that people don't agree. This is a reflection that the American populace is divided. And I find that often when people criticize gridlock, they're not agreeing with that. Well, the way to persuade people, to pardon an expression from a president I mentioned earlier, Teddy Roosevelt, is was most famous. He was once shot in the chest, and the bullet hit a stack of papers in his breast pocket, and he went out and gave a speech anyway with a freaking bullet in it. Right? He had an amazing willpower that's rivaled by probably no other president since. But the president has a bully pulpit to engage in sorts of activities. So we have this background, right? Okay, we'll discuss a take care clause. The president has his duty to take care that the laws are faithfully executed, right? The president has to execute the laws. Does Congress have any obligation to pass laws? No. Does Congress have any obligations to confirm the president's officers? No. But all too often today, the sense has become that if the Congress is not getting along, they're doing the wrong thing. I push back against that a little bit, but not too much. What we ended up with in the majority opinion, sorry, I have other stuff in this presentation, not really interested in. I give this one in a lot of different contexts. Okay, that's enough for now. It's Youngstown. So we have here in this case then is a conflict where the president has effectively said, because the Congress won't confirm my people to the board, I'm going to use this recess power as a way to let out some steam. The court rejects that emphatically. And on that front, it's 9-0. Okay? Any questions on that? I'm going to go through the actual case itself, but I want to dwell on that because we'll come back to this next week when we do the immigration case, or week after, whenever it is. Anything on that background? Okay, so let's actually move into the opinion itself. Again, I think I mentioned this on the first day of class. I appreciate that the readings are longer than usual, but I do this quite deliberately. All the readings are assigned the first week of the semester, so you know exactly what you have. It's very rare that law students ever actually read an entire opinion start to finish. This isn't even the entire opinion, it's about twice as long. This is actually an edited version, believe it or not. The actual opinion was over 100 pages. So this is actually an edited version. But this gives you the full flavor, or at least a significant chunk of the flavor of how the justice write and go back and forth. I think when this case first came out, I gave my students the entire decision, so you have an edited version which did not exist at that time. So Justice Breyer's majority opinion focuses on three main questions. Three main questions. Okay? And the questions follow and track the text of the Constitution. Okay? So let me read the recess clause for you again. It says, the president shall have the power to fill up all vacancies that may happen during the recess of the Senate. Okay? So the first question, and I wrote them out here. You're welcome to put these in your notes or phrase them however you wish. But the first question the court must consider is, what is the recess of the Senate? What is the recess of the Senate? Okay, so let me explain how this works. Every 2 years we have a congressional election, and every 2 years roughly 1/3 of the senators are up for re-election. So each Congress, right, lasts 2 years. We are currently was the 115th Congress, whatever it is. There are two kinds of breaks that Congress can take. There's an intersession break and an intra-session break. Inter versus intra. Is that Charles? Yeah. Charles, tell me please, what's the difference between an intersession and an intra-session break?
Within between the, or with,
which is which?
Within the session, the session, and in between separate sessions.
Which is which?
Inter is within, inter is between two sessions, intra is in one.
Okay, good. I'll explain that again. It's a little tricky to follow, but you're right. Each Congress meets for 2 years, and they usually have two different sessions. Okay. The video I showed you here before, I think I already closed it. If you notice, it said this begins the second session of the whatever Congress, right? Remember that? I watched that video 5 minutes ago. Usually at the beginning of January, Congress meets on January 3rd. They end the first session, they start the second session. Okay. Usually they move from one section to the next without a break. They say, you know, this section's over, the new one's beginning. An inter-session recess is between the first year and the second year. Inter means between the first and the second. There's actually an ending of the first session and the beginning of a second session. Everyone understand that? Intra-session means during a single grouping of meetings, you take a break. So for example, a lunch for an hour, right? A lunch break. A session break. You go home for Christmas or Thanksgiving. That's an intra-session break. The difference is this. With an intra-session break, you say we're going to break for X number of days and we're going to come back at a specific point. With an intra-session break, you define when you return. With an intersession break, there's no date of adjournment. You'll come back whenever you come back. Everyone understand the difference between the intersession and intrasession. If you don't get it, the case won't make sense. Intersession is from one session to the next. Intrasession is during a session like a lunch break or a Christmas break. That's how you can easily think of it. Everyone with me? So the first question, right? The first question is whether the president can make a recess appointment during both. Everyone agrees the president can make it during the intersession. But the dispute, the first question is whether they can make it during the intrasession. The dispute is over. Whether the president can make a recess appointment during an intrasession break. Everyone understand that? The second question for the court to consider is, what does it mean vacancies may happen? Vacancies may happen. The text says the president shall have the power to fill up all vacancies that may happen during the recess of the Senate. There are two ways of reading that. So imagine Congress takes a recess during summer. Everyone goes home to the farm, right? And in the middle of July, the Secretary of State dies. That, in every sense, was a vacancy that happened during the recess, right? The guy died while Congress was on recess. So one interpretation is that the vacancy happens, the person literally dies or resigns during the break. That's one way of reading it. The second way of reading it is what happens if the person dies the week before the recess, but because there are no phones, no one finds out about it. What if the vacancy arose prior to the recess? Can the president fill a vacancy that arose prior to the recess? Again, no one disputes if the person dies during the recess, you can fill that. But in our case, with the labor board, that vacancy was open for years, right? That vacancy's been around for a while. Okay. The third issue that the court has to confront is how long must a recess be in order to trigger the recess appointment clause? How long must the recess be to trigger the recess appointment clause? Is a break of 72 hours, 3 days sufficient? Is a break of 10 days sufficient? Do these little stupid pro forma sessions even count to punctuate 72-hour breaks, or is this just one long 2-week recess? Okay. These are the three questions which are directly compelled by the text of the Constitution. Everyone get the three questions that the court has to confront. So before I get to how the court resolves it, before I get to what the court does, I'd like to address how the court goes about analyzing this question. So that Danielle? Danielle, from Justice Breyer's perspective, what is the relationship between text of the Constitution and past practice? What Congress has done before? What's the relationship for Justice Breyer?
He thinks that past actions are higher than the past.
Oh, you're right. He won't admit that, but you're right. I'm glad you said that. So say it one more time. You're exactly right. Breyer will never admit that, but you're right.
That past would be higher than the effective.
Why do you think Justice Breyer admits that in his dreams, never out loud? Why do you think he admits that?
Because he said that since they've done this in the past, and Congress has been against it, that they should defer.
Very good. So Justice Breyer, again, he didn't actually say this, right? But this is what he's actually saying. Danielle, I think hits on the head. What Breyer is basically saying is, look, the text of the Constitution is ambiguous. That's how he gets around it, right? He says the text is ambiguous, right? Unclear what a vacancy has to be. Unclear when the recess is. Unclear what may happen is. So Breyer said, look, I don't know what this text means. Scalia does. But Breyer's like, I don't know what this text means. So because I don't know what this text means, I am going to look to practice. I am going to look to see how this provision has been interpreted by Congress and the President over the last 200 years. And I am going to defer to that practice when I see that the President and Congress agree. I am going to defer to this practice when I see the President and Congress agree. Where have we seen this before, Amber, this idea of deferring when the President and Congress are on the same point? Where have we seen this before? What case? What big case do we talk about deference when the President and Congress are on the same page? You haven't done that many yet. No. Come on. I mentioned that 3 times today. Caleb? Okay, so we're going to cover out 100 cases this semester. You're going to need to know them. This one's a biggie. Dylan?
I'm not sure either. I would say INS.
Youngstown. Youngstown. I'll come back to the 3 of you in a minute. Youngstown, you're off the hook. Justice Jackson. All right, remember what Justice Jackson said? Justice Jackson said, when the President and Congress agree, when there's this history of past practice, right, the courts do not scrutinize it. The courts will not second guess the executive branch. That's what Breyer is basically saying here. When there's a lengthy history, again, Breyer and Jackson are on the same page. When there's a lengthy history of the President and Congress agreeing, it's not for the courts to second guess. When there's a lengthy history of Congress agreeing, it's not for the courts to second guess. This is Jackson and Youngstown. Breyer makes the same point. So for Breyer, acquiescence. Okay, come back. Amber, what does acquiescence mean? What does it mean to acquiesce? The word was used a couple times in the opinion. You know? Caleb, what's acquiescence?
Without objection.
To give in. By the way, if there are words in the opinions you don't know, you need to look them up. Right? You're in the 2nd semester of law school, so you need to look up words you don't know. Acquiescence means when Congress gives in. In other words, the executive does something and Congress doesn't object, they acquiesce. They don't object to it. They give in. Right? They acquiesce. They don't give in. I'm sorry, they give in. So for Breyer, if there's a lengthy history of the executive doing something, Congress not complaining, well, who are we to judge? Why can't those branches of government be in charge of deciding what the Constitution means? And that is really what motivates Justice Breyer's decision, right? He acknowledges that the recess power should be the subsidiary, the secondary method of appointing. But he said there's a long history of Congress making these sorts, the President making these sorts of appointments. So first, Amber, is there a history of the President making intra-session recess appointments?
Yeah.
Okay. Where's this history from? When did this history begin, and more likely?
Well, I know McCullough mailed them this Friday.
I'm asking for a year. About when did the President start making these interests? I'm asking for a year. Caleb?
I don't have a year, but didn't they say basically since the 2nd Congress, that's just how it's been?
No. And in fact, there was Attorney General, let's see, was that Elizabeth? When did these start being made, these intra-session recess appointments? When did these start becoming very common? Anyone? World War II, right? Until basically the Teddy Roosevelt administration, there were no really recorded instances of intra-session recess appointments. They were, if they happened, they were very rare, and they were by Andrew Johnson in 1863. This was this tumultuous time when there was such upheaval, right, in American history that it's probably not the best indication. At the turn of the century, the 1920s, 30s, and then really during World War II, presidents started making these intra-session recess appointments. They started making these intra-session recess appointments. So I'll come back to Elizabeth. What do we make of a practice that was unheard of for the first 130 years of our republic, and then been consistent for the last 80? How do we understand that? It was never done the first 130 years, and the last 80 has been pretty consistent. What do we make of that? Good, good. And that's what Breyer says. He says, look, it's true that there were not many of these intra-session recess appointments, but there were also not many intra-session breaks. Generally, Congress would come to Washington, and they would stay and work straight through. Then they go home. So all the recesses were inter-session. Breyer says this idea of the intra-session is fairly novel. So the most significant holding, right? First, Breyer says the president can make recess appointments during a session, intra-session. Had the court held otherwise, as Scalia would have done, basically the recess appointment power would have disappeared. Because all Congress is do is just never going to break. It's never going to break. Okay? The next question that they have to confront is how long must a recess be? Zachary, how long must a recess be in order for it to be, how long must the break be to trigger the recess power?
They were pretty ambiguous.
Yeah. What did they say? Exactly right.
They said 3 days is too short, and then they were like, well, there's some that last 10 days. And they said that was too short too. So they never really said like a minimum or maximum.
It's like Goldilocks, right? Not too hot, not too cold. Yeah. Zachary is exactly right. He's exactly right. Breyer basically says, well, 3 days is definitely too short, right? Because we have 3 days here. And based on past practices, we can't find anything shorter than 10 days. So we'll basically say 3 is too short, but 10 to be safe. Where does he get this from? Right? Shruggy Motican, I don't know. He basically looks to past practice and says, we can't find any instances where one was done in less than 10 days. So we're going to make that our floor. We're going to make that our minimum. Again, Zachary, you're exactly right. It's ambiguous. We don't know where he gets this from, and Justice Scalia rips him apart on this front, saying you're making this stuff up, right? This is fiction. So now we know 3 days is too short, 10 days is also probably too short, so 11 to be safe, whatever. So that how do you hold? A recess of more than 3 days but less than 10 is too short. So it's got to be more than 10. Okay, you can make up numbers, go for it, right? The Constitution spells out elsewhere this many days, that many days for veto. Here it's silent. Breyer makes it up. So this is probably the more unsatisfying aspects of the opinion, I'm sure, when you were reading it, for those of you who got this far. The second question about vacancies that may happen. This is also significant. So again, here are the two arguments. On the one hand, you can say vacancies that actually arose during the recess, right? Someone literally died while Congress was on summer break. No question you can fill that one. What about in the case of the National Labor Relations Board? These positions were empty for years. President Obama tried to fill them. He couldn't because Republicans didn't like his picks. Can you do this? Again, the most natural reading of vacancy that may happen during the recess is the person drops dead while the Congress is in session. That's the most natural reading. And Breyer basically says, yes, I admit, right, the text is there. And then as Daniela said very wisely a moment ago, but I don't care, right? The text cannot trump what I see as a purpose of the Constitution, our democracy work. The purpose of our Constitution is to make government effective. We do not want to handicap the president. We do not want to cripple him if he can't put someone into office in the need. So we will not read it. Again, historical practice was ambiguous. Some attorney general said, one way, some said the other way. So what did Breyer do? He took a text that seems pretty clear to me, and he read it to be ambiguous and said the underlying purpose, citing McCullough and others, is to give meaning to the Constitution and to make our Constitution great again. I'm sorry, make our Constitution work. Right? So even though the vacancy arose before, just as Breyer says, it's still okay. Any question on that part of the holding? Okay. Helen, the third of these stupid pro forma sessions where they come in, they gavel, and they leave, they get out of town there. What does Breyer make of these pro forma sessions?
Well, he says that because the Senate calls them sessions, we should regard that as
Exactly right. So here's the conflict, right? President Obama said, wait a minute, you guys are not in session. Look at this picture, right? There's no one in the room. The room's empty. There's no session here. However, under the Senate's rules, in their own manual, in their own orders, they said, we are in session. Hear what he said. We now begin the new session of Congress. You heard what he said. And Breyer, again, who wakes up in the morning, says, how can I defer more to Congress? Said, if the Senate says they're in session, they're in session. That's the end of the story. If the Senate wants to meet every 3 days in these stupid pro forma sessions, I don't care. They're in session. Therefore, there's no recess. And because they held these every 3 days, a 3-day break is not long enough. Therefore, the recess appointments were not valid. Everyone see that? This was a part the president lost. Obama lost this part. He won everything else, which is actually a much bigger victory. But the court said the 3-day break is not long enough because these pro forma sessions are actual sessions of the Congress. Everyone get the Breyer opinion? Yes, sir.
Breyer said that he could believe that it wasn't a political issue or a political issue that they should be deciding, it's just a constitutional issue.
Right.
So why did he? How can you say that and then at the same time say that the vacancy doesn't have to arise during the recess? Because what that does is it automatically says you can fight with Congress, you can fight with the Senate. The whole session, leave the building.
And this is the point Justice Scalia raised, right? The majority opinion basically says when there is this sort of battle, right? This isn't a case where someone died suddenly. This position was open for a while. And Scalia says in his concurring opinion, which reads like a dissent, if the Senate won't vote on the president's nominee, pick someone else, right? The recess appointment power, Scalia says, should not be used when there is this disagreement. If the president doesn't want, if the Senate doesn't agree with the president's nominee, pick someone else. You're right. Are there questions in the majority? Yes, sir. Travis.
And it kind of relates to Scalia's concurrence also. I mean, why didn't they just limit this to the 3 days isn't enough performance? You know, I mean, they could have limited the whole thing to the performance sessions are sessions.
Right.
3 days isn't enough for a recess, and then not really held on the rest of it. And they wouldn't have expressly granted the power. They wouldn't have.
I mean, why wouldn't 4 days be enough?
Yeah. Well, I mean, I'm just saying. You know, I mean, they obviously didn't give the number here anyway.
So here's actually some inside baseball, which is not clear. Do you know why they met every? So the Democrats control the Senate, right? The Republicans control the House. Do you know why the Senate met every 3 days? But the Democrats control the Senate.
Right.
Oh, why wouldn't the Democratic Senate just say, "Oh, screw it, we're going to take 2 weeks off, let Obama appoint whoever he wants"?
Oh, because the Republicans wouldn't let him.
But the Republicans were the minority in the Senate.
But in the House.
What? The German clause. What does the German clause say? Very good. 3 days. Neither house can adjourn for more than 3 days without the consent of the other. The House Republicans would not let the Democratic Senate adjourn for more than 3 days to block the appointments. This is why they met these 3-day pro forma sessions. The House Republicans prevented the Senate Democrats from adjourning for 3 days in order to allow Obama to appoint his people. This was done the same way with Bush when he was in office. They just flipped it around. In fact, Scalia actually mentioned there was a brief by Ted Kennedy one time, and they brief by Mitch McConnell. They made the same arguments. Okay. I want to focus on the end of Breyer's opinion. If you notice, he cites Justice Kennedy's opinion in Clinton v. City of New York. And you recall we studied Clinton v. City of New York last week. Justice Kennedy basically says the separation of powers exists to protect liberty, right? The reason why this separation of powers is to prevent tyranny. Kennedy also said, we don't allow the powers to shift voluntarily, right? We don't allow the Congress to give the president this power over the line item veto. Remember this? Right? Kennedy said we can't allow the parties to renegotiate their own powers because that is a definition of tyranny. What do we have here? Right? What do we have here? The court is allowing a shift from the Senate's power over confirmation to the president's power over recess appointments. Right? So Breyer basically mentions this and says, well, yeah, all that stuff's well and good, but we need an effective government. We need an effective government. We interpret the Constitution as a whole in light of our experiences, and we look to practice to inform it. So effectively, Justice Kennedy joined this. That's why this became, even though it looks like 9-0, it's really 5-4. I mean, it's barely, it's not really 9-0. And Justice Kennedy, who wrote a strong concurrence in Clinton v. City of New York, if you recall, against Breyer, right? In Clinton v. New York, Kennedy concurred against Breyer's dissent. Here, Justice Kennedy came on board and joined Breyer's opinion to say that the separation of powers can be shifted, well, because that's how we've been doing it for a very long time. It's hard to reconcile Kennedy's opinion in Clinton v. City of New York with his opinion here. And indeed, Justice Scalia's opinion keeps citing Kennedy's concurrence in Clinton v. City of New York. He cites like 4 or 5 times, trying to say, hey, Tony, come on back to the dark side, friend. Right? You know, remember what you wrote 20 years ago? Come on back. But Tony was not, didn't want to play with Nino. So Scalia's dissent, and I don't have nearly enough time to adjust this. Scalia's dissent effectively calls for following the text of the Constitution. He says, look, the text of the Constitution here is really clear. Vacancies that happen, that means it may happen. The recess of the Senate, the recess, the means one. There is one recess of the Senate, Scalia says, and that's between session number 1 and session number 2. There are 2 recesses of the Senate. This doesn't apply to breaks during. And frankly, Scalia has the better argument as to both text and original meaning. I mean, it's not even close. The only place where Scalia suffers, though, is past practice. Because for decades, at least since the 1920s and 30s, every president has made these recess appointments during the session for positions that did not arise beforehand. So for Scalia, then, is that Clayton? Clayton, for Scalia, what do we do then when you have a conflict between the text of the Constitution and past practice? Which one prevails? What would Scalia say to that?
He would say the Constitution.
Why?
Because it's the ultimate authority.
But why shouldn't we look to how the branches have enacted, have implemented the Constitution? Why should we not look to past practice?
Because it's kind of overriding what the Constitution wanted.
Good. What do you think, Kason?
It's just a valuable check on their behavior.
Okay. What do you think, Emma? For Scalia, why does the original meaning of the Constitution trump what government's actually done? Why should that prevail over practice of how presidents have actually implemented this? What's his objection?
Because our just to be doing it is not necessarily right, because we could be interpreted away from the actual meaning of the Constitution.
Yeah. Okay, good. I think the 3 of you hit more or less where I want to go. What Scalia says is a separation of powers exists to protect not the interests of the president, not, but the interests of the individual. The separation of powers exists to protect individual freedom, not to ensure that the Congress and the executive can function effectively. So when when the courts defer to the very branches of government that would otherwise violate the Constitution, they're giving up on freedom. So, Kiara, let me ask you this question. Do you think the executive branch can be trusted to read their own power narrowly? No. Do you think Congress can be trusted to read their own power narrowly? Why not?
Because they are
Yeah. What do we say? Ambition must be made to counteract ambition, right? Of course the executives have this power, right? If you're the attorney general, you say, of course you can make these recent appointments. Of course you can make those appointments, right? And if you're Congress, you're going to say, of course you can't do that. So what Scalia's point is, we can't trust these other branches. At best, the text is clear. The history of the Constitution is clear. Even if presidents have been violating the Constitution for 70 years, that is not a license to condone it. Even if every president since William Howard Taft, right, has been breaking the Constitution, that does not sanction us to follow it. The mere fact that the branches agree on something does not require deference. Again, Scalia is rejecting Jackson. He doesn't cite it, but he's saying, even if the president and Congress agree, you're damn right I'm going to be skeptical of this. Even if the president and Congress are on the same page, yeah, I'm going to second guess it because the Constitution, the text, the formalism, just as black, all clear. Efficiency is not a goal of our government. Gridlock is a feature and not a bug. And Scalia closes and he makes a point that I think is worth stressing. In the long run, David, I'll go to your last question. In the long run, which branch of government has a better expanding? Which branch of government is more able to expand its own power in the long run? The president or Congress? Really, why?
I mean, because they have to check whatever the president does. I don't think the president can just.
How many members are there of Congress, David? A lot, right? How many members of the president are there? Who do you think is better able to concentrate his power? Congress or the president? Concentrate his own power, yeah, over the long run. President. I don't care what his party is, whether his name is Bush or Obama or Reagan. President to president concentrate their power in their own office. It happens without fail. Every president comes and says, I'm going to change this, change that. No, they continue everything that's been done before. And Scalia's point is that over the long run, the president has the power to aggrandize and collect this power. And if Congress fails to check it, and the court defers to the executive who's not being checked, this again, if the courts defer to the executive who's not being checked by Congress, there's no one left to defend the separation of powers. All right, any questions? I will see you all on Thursday. Thank you very much.